Well, we have an update in another Chile-involved lawsuit, and this time it's the lawsuit of Lafferty v. Hoffman. As it involved a driving incident, I thought I'd introduce it with my drive a few days ago. I think this was the second federal lawsuit that Chile was involved in, and we have the findings, conclusions, and recommendation of the United States Magistrate Judge. Pursuant to 28 USC 636 brackets B and Special Order 3, this case has been referred to the undersigned United States Magistrate Judge for pre-trial management. Now before the court is defendant Holman Smith and City of Forney's renewed 12B5 motion to dismiss for insufficient process and brief in support. As detailed here, defendant's motion should be granted. 1. Background. On April 26, 2022, plaintiff filed this pro se fee-paid civil action against the City of Forney and city police officers, Holman and Smith, alleging civil rights violations occurring in November 2021 pursuant to 42 USC 1983. On June 29, 2022, plaintiff attempted to serve defendants by leaving summonses with the city manager's executive assistant and a Forney Police Department records technician. In response, defendants moved to dismiss plaintiff's claims for insufficient service of process under Rule 12b-5 of the Federal Rules of Civil Procedure. Upon the recommendation of the undersigned, and absent any objection to the same, the district judge granted defendant's motion in part, extending the deadline for plaintiff to effectuate service of process to March 24, 2023, and admonishing plaintiff that failure to properly serve any defendant by that deadline would result in dismissal without prejudice upon the defendant's re-urging. To date, however, summonses have not been returned as executed. Defendants thus renew their motion to dismiss plaintiff's claims for insufficient process under Rule 12b-5. Plaintiff has not filed a response. 2. Analysis. For service to be effective, plaintiffs are expected to comply with the mandates of Federal Rules of Civil Procedure 4. And reference, finding that pro se litigants are not exempt from compliance with the rules of service. Without proper service of process, the court lacks personal jurisdiction over a defendant. Again, another reference. Rule 12b-5 permits a challenge to the method of service attempted by a plaintiff or to the lack of service. Again, another reference. A motion to dismiss pursuant to Rule 12b-5 turns on the legal sufficiency of the service of process. When service of process is challenged in a Rule 12b-5 motion, the serving party bears the burden of proving its validity or good cause for failure to effect timely service. Again, another reference. To establish good cause, the non-movement must show at least as much would be required to show excusable neglect as to which simple inadvertence or mistake of counsel or ignorance of the rules usually does not suffice. And then again, another reference. Further, a plaintiff's pro se status does not excuse the failure to properly effect service. Again, another reference. Here the court extended plaintiff's deadline to properly serve defendants to March 24, 2023. Yet to date, plaintiff has failed to effect service of process on any defendant or respond to the motion sub judice. Thus, dismissal of this case is warranted. Another reference. Dismissing case without prejudice when pro se plaintiffs failed to respond to defendant's Rule 12b-5 motion or did not demonstrate good cause for their failure to effect service despite the court's 21-day extension to effect proper service. 3. Conclusion. For the foregoing reasons, defendants Holman, Smith and City of Forney's renewed 12b-5 motion to dismiss for insufficient process should be granted, and this case should be dismissed without prejudice, so recommended on June 22, 2023. So, after over a year of originally filing this lawsuit, with the help of Chile, the plaintiff was not able to correctly serve the defendants. I mean, the lawsuit was a load of rubbish, and I did a series of videos on his claims and with the video of the actual incident. Unfortunately, Chilli struck some of those videos as part of his wage of war against content creators, but I won't bother going there because everything's over. I doubt he'll refile the lawsuit. He was found guilty criminally for the event, so his chances, I think, well, they were remote anyway, but they're non-existent now. Thanks for watching.